Hey, Gabe, I got another topic for you.
Okay.
You ready?
Yeah.
All right, let's go to another one. Here's another one here. How about closings?
Well, you just said you closed 35,000 transactions. What do you need me here
I'm
for?
putting this one on you, though, Gabe. What do realtors need to know about closings? You know, there's confusion.
Yeah.
When I talk to realtors around the state, right, of what they can and cannot do in a closing.
Yeah.
And I know that parts of the state handle closings differently, and realtors in parts of the state do their job differently than realtors in other parts of the state. Okay, that's just what it is in Iowa.
Yep.
But the question I often get is, how much of a closing can I do from the realtor? Can I do the closing? Do I need a lawyer to do the closing? Do I need a licensed closing agent to do the closing?
Yep.
You know, I'm sure you've had those questions on the hotline too, Gabe.
I have, absolutely, George, and I think a lot of those same exact questions you just mentioned, but I think what I want to tell the viewers before we even dive into this conversation is if you are one of those people who is maybe a little questioning of what you can and can't do and what authority as a realtor you have in a closing, I'm not surprised, because I have to admit, when I go through these rules myself, they're not the clearest as to what these sort of responsibilities are. And I think that confusion is justified. And I think what we're going to do today is try to talk about some things that we're confident, especially in your experience as an attorney for 40 plus years, closing 35,000 transactions. You know, what do realtors customarily do? What are they safe doing? What are areas they absolutely can't do? And maybe some of those middle grounds, right? Because sometimes there are things as a realtor that maybe you can do, but maybe you don't want to. And maybe it's a better idea not to do them, right? Because what we're here to do is try to give our members information to lower their risk in the industry.
And when I get that question from a realtor, what can I do, what can I not do, I refer them to the code.
Yes.
The code has a section, again, 193E, look it up. It says closing transaction.
Yes.
Closing transaction. Let me read a little bit to you, okay? It says, it shall be mandatory. It shall be mandatory for every broker to deliver to the seller in every real estate transaction, at the time the transaction is consummated, a complete detailed statement showing all of the receipts and disbursements handled by the broker. Also, the broker shall at the same time deliver to the buyer a complete statement showing all monies received in the transaction from the buyer and how and for what the same were dispersed. And the key is this, Gabe. It goes on to say, the listing broker shall be responsible for the closing, even though the closing may be completed by another licensee.
Well, stop there. Aren't we done with the conversation right there? Listing broker's responsible unless the other licensee takes over. I mean, it seems to me right there that the realtor can do everything with the closing. It says it right there, doesn't it?
Not so fast, Gabe.
All right.
Not so fast.
Okay, we got a little more to talk about.
I think we got a little more to talk about, okay? So we'll use that as a basis for the code, okay?
All right.
But I think if we read further and discuss this a little bit, I think we'll come to this conclusion that there are certain things that the code absolutely allows realtors to do as far as closings go. There's other things that the code absolutely forbids realtors to do as far as closings go. Yep. And I'm going to go back to one thing that I always talk to realtors about when they talk about doing their closings is the liability. Do they really want the liability of a closing? Do you really want to handle all that money, be in charge of that transaction, make sure everything is dispersed according to your closing disclosure?
Yep.
And then be liable if there was a mess up somewhere.
Right. Because when you start to get into these gray areas, you're taking on further liability, right?
Oh, exactly.
Absolutely. And so, George, going back to just that first provision you read, you know, the one that you said it shall be mandatory for every broker to deliver to the seller in every real estate transaction at the time it's consummated, a complete detailed statement showing all the receipts and disbursements handled by the broker. Is that saying that the realtor should be preparing a closing disclosure?
I don't think that's what it's saying.
Okay.
I think what it's saying is that once you get that final closing disclosure signed off by all parties, it's the duty of that broker to make sure that their buyer, their seller, gets a copy of that final closing disclosure. I don't think it's telling the realtor to prepare that disclosure. Quite frankly, Gabe, you had me thinking now. I can't even think of one time where I've had a realtor prepare a closing disclosure.
Okay. 35,000 transactions.
That's usually, the closing disclosures are usually prepared by the closing agent,
Yeah.
right? The attorney, the title company, who's ever going to close the deal.
Okay.
And if you're a realtor, why would you want to do that?
Right. Right. No, exactly. I mean, there's all kinds of legal issues that can arise in that sort of situation, and we're going to talk a little bit more in just a few minutes about the things you can do as a realtor,
Yeah.
but you want to be careful there. But again, George, I think the other provision here is, if the closing transaction is handled through an unlicensed escrow agent and the escrow agent renders a closing statement, the listing broker shall ensure that funds which the broker has received or paid as part of the transaction are accounted for properly. And I think that's exactly what you said.
Exactly.
I think it's customary in a lot of places where closing companies, attorneys are hired to close transactions. In those situations, though, I think what you can glean from the law here and the license law for the realtor is make sure if monies came through your trust account or came through your office or through you in part of this transaction, you want to make sure you're looking at that closing statement. You want to making sure they have all the information as you accounted for things, properly indicated as well.
Yeah, and I would agree. Gabe, let me share an experience I had.
Please.
When it comes to a realtor handling a closing,
Yeah.
okay? And this is a realtor that was from Central Iowa. And he called me once. He goes, George, I think I might be in trouble. I go, why do you think you might be in trouble? He goes, well, I handled the closing for a friend of mine. He goes, and the bank let me do it.
Okay. Yeah.
Okay, and the bank let me do it. Now, this was years ago. This is when we had the HUD statement versus the closing disclosure, okay? He goes, and the bank let me do it. I go, okay. I go, so what's the problem? He goes, well, I got the money, and I got the loan money, I got the down payment, I put together a HUD, I dispersed checks. The next day, I started getting calls from people I dispersed checks to saying the checks had bounced.
Oof.
I go, what? He goes, the checks had bounced. I go, how can the checks bounce? Didn't you have that money in your trust account? Weren't they good funds? I mean, you can't disperse money you don't have,
Sure.
right? He goes, no, they were good. And I had them in my trust account. The problem, George, is that I have two trust accounts, and I deposited them in one trust account and wrote and dispersed the loan out of another trust account.
Ugh.
Mortgage payoff was wrong. There was per diem that had to be added. All these other checks were bounced. I said, well, partner, we got to talk about this,
I'm sure you got a bunch of thrilled people in that situation.
Yeah, and then we went and luckily we were able to help him smooth it out. But in any event,
Wow. But
that's the liability. That's the risk you take, and biting off more than maybe you want to.
And we're going to get to this, I think, in the latter part of this discussion, but I have had, George, it makes me think of a couple questions that have come to me. And every once in a while, I'll have people that will call that will say, we weren't involved in the actual listing or sale of the home, but somebody wants us and our brokerage to just come in and close the transaction. I mean, at that point, you're really not engaging in any type of real estate licensing brokerage activities at all. I mean, you're acting as a closing agent. And of course, in that situation, no doubt about it, you'd have to have a closing agent license or a license to practice law.
Right, that would be a no-no for an agent to do that.
But this stuff, I mean, this comes up. I mean, that question I just said, that's come up multiple times on the hotline to me. So again, that's why we need to be talking about these things.
Yeah.
We need to bring these conversations right out on the front of the table and make sure we're doing the right thing to protect ourselves and protect ultimately our clients that we're serving. I think that's so important.
Now, Gabe, there are things that an agent can do in a closing, though, right?
I think there are. Yeah, absolutely.
And the first thing that the code talks about is, what constitutes acts of real estate, which they can engage in.
Yes.
Okay. Things such as helping someone sell, exchange, purchase, rent, or lease real estate, who lists, offers, attempts, or agrees to list real estate for sale, exchange, purchase, rent, or lease, advertises, holds oneself out as being engaged in the business of selling, exchanging, purchasing, renting real estate, et cetera. So there are things that the code does allow. Negotiations, for example, help someone negotiate a deal, collect rents, help or assist prospects in procuring property, prepare purchase agreements.
Yes.
Okay, those are things a realtor can do, and that's specific in the code.
How about, we got to go back to the code. You just listed a bunch of them. Number 9 that talks about document preparation that a realtor can do. It says realtors can prepare offers to purchase or purchase agreements, like you said, listing contracts, agency disclosures, real property, residential, and agricultural rental agreements, real property commercial rental agreements of 1 year or less, groundwater hazard statements, including any modifications, amendments, or addendums to those specific documents, okay? That really talks about the sorts of documents that a realtor who's engaging in the practice of real estate can prepare.
You know what that tells me, though?
What's that?
That tells me if you can prepare this, there's something over here you can't prepare.
I think you're absolutely right.
If you look at what it says.
Yeah.
We'll let you do that. Well,
Yeah.
you can prepare this, but not this.
It's almost like the presumption is that you probably shouldn't be preparing anything unless it's something we've specifically promulgated in the law and given you the authority to prepare, right?
Right.
So, George, again, I got to read the code just a little more here. We have to do that to make sure we're talking the right subject matter material here. But we just read the acts of what somebody can do with a real estate license, right?
Correct.
Was one of those acts close the transaction?
I did not see that.
Or settle everything off? I don't see anything about
I didn't
that.
see that. I didn't see anything about preparing a settlement statement or closing statement or dispersing. I didn't see that.
Okay. So let's go. There's another rule in the administrative code that talks about the unauthorized practice of law that says realtors, right? They have to know this because what it says is all Iowa real estate licensees should be aware that Iowa Court Rule 37.5 authorizes non-lawyers to select, prepare, and complete certain legal documents incident to residential real estate transactions of four units or less. The preparation of documents beyond that, beyond what we just said, authorized by court rule, may constitute the unauthorized practice of law. And the next rule, it talks about how you can prepare documents if you're the principal to the transaction, but what else does the rule say that's important for the realtors?
Well, the rule, I think, tells you what they can prepare.
Yeah.
The rules tell you what they can prepare, and the rule says that realtors can prepare, or the documents they can prepare shall be limited to offers to purchase or purchase agreements, provided the parties are given written notice. These are binding legal agreements, right? Yes. I think there's a little disclosure about that.
Yep.
And competent legal advice should be sought before signing. They can complete groundwater hazard statements. They can complete declaration of value forms.
Purchase agreements and amendments to purchase agreements, groundwater hazard statements, declaration of value forms. That's what else, George?
Declaration of value. That's what the code says.
That's what the code says. That's what it specifically articulates what a licensee can do without possibly being in the unauthorized practice of law, right?
All right. Now I'm gonna
go ahead.
I'm going to go back to what I said a couple minutes ago,
Yes.
okay? That tells them what they can do,
Yes.
right?
Yes.
Which tells me that
There are things that you absolutely cannot do, right? And that's so important. That's such a key takeaway for the viewers today. But
that code section there?
There are some things right here that say, exactly definite things you cannot do, right?
Okay.
It says preparing deeds, right? Can't do that. Real estate installment sales contracts, right? Can't do that. Affidavits of identity or non-identity, you cannot do that. Affidavits dealing with payments of spousal support, right? Can't do that. Any documents necessary to try to fix title-related issues, can't do that. These are some things that point blank says you can't do. This isn't the list. This isn't the limited list. It can be more than that. The code says that. But it points out definitely cannot do these things.
And Gabe, I see this on a regular basis from agents saying, my client owes child support. My client is current on child support. Will you accept an affidavit from me stating that he's current? No.
Nope.
Can I prepare an affidavit and have him sign saying that he's current? No. Okay. I've had realtors want to prepare powers of attorney. I know that's not one of the lists there, right? But be careful about that, realtors. That could be considered the practice of law. Again, depending on what the body of the power of attorney says. But one thing here that I thought of, Gabe, while we're talking about practice of law or the unauthorized practice of law is this. I don't know how many people know this, but we all should know this, is that the Iowa Supreme Court has a commission on the unauthorized practice of law. And they investigate allegations of the unauthorized practice of law. And we as members of the Bar Association, we get notices of some of those investigations. And when they find someone that has been charged with the unauthorized practice of law. We get notices of who they are and watch out for these people, right? And nobody wants to be that person, right? So I think the agents have to be careful in what they do. Now, that being said, I know there are clients that will push agents to do things that agents do not feel comfortable with. Prepare my power of attorney. Why should I pay a lawyer to do my deed? You can go to Office Max and get they think, right? And get a blank, and agent, you can fill it out.
Come on, you've been selling real estate all these years. You're my expert real estate advisor.
Exactly.
I'm paying a lot of money in commissions for your services. Come on, seriously? You can't do that for me?
You just told me you've been practicing for 35 years, right? Why can't you prepare a deed for me?
Exactly.
And that's where the realtors really have to say no.
And it can be so hard. You know this. But it can be so hard sometimes telling somebody that needs help, I can't do it. And it's just human nature, right? But it's so, so important to stay in your lane, realize what your role in the transaction is, continually communicate that to your client, because it's not in their best interest for you to be giving advice that's outside of your area of expertise. It's not only bad for you, it's bad for your client, and your job as their fiduciary is to do everything in your power to make sure every second of that transaction that their best interest is in mind and that you're looking out for them.
Correct. And I'm going to say a word here to the brokers that are viewing today. Okay, brokers, you have your responsibility to supervise your agents, to supervise your licensees. Okay, this is one area where you need to be aware of what they are doing. Supervise them in this area. Don't let something small grow into something very, very big that will be very difficult to resolve at the end.
I think that's absolutely right, George. And I think the other thing we need to look at here, just to finish up this topic, is, again, we talked about this idea where the code says there are certain things, you can do as a realtor in a closing. But as we just talked about, there's all kinds of things that could come up that you probably could not. Right. Keep in mind, right, that you have lawyers, you have closing agents. Right. Closing agents are also licensed and certified under a whole nother provision of the code. And you have to have a closing agent license to engage in any real estate closing services. And real estate closing services includes, but is not limited to, preparing settlement statements, right? Determining that all closing documents conform to the parties' contract requirements. Do you see any issues if a realtor was sitting down at the closing table and closely vetting the purchase agreement and contracts and advising on whether the mortgage-related documents, carry out their interests and those sort of things? I mean,
oh yeah, there's all kinds of red flags there, right?
There's all kinds of stuff you need to be careful about, right? Yeah. So it just goes to show that there's licensing and a group of professionals that are closing agents. There's a group of professionals that are attorneys. Please just understand your limitations. Make sure you stay in your lane. Yeah. So you probably can. Yeah. What kinds of things do you think you can probably do? As a realtor.
Yeah, as a realtor, I think you can, be at the closing.
Yep.
If it's allowed. I mean, depending on what the closing agent rules are, right? Be there.
COVID makes that a little.
COVID makes it a little difficult sometimes, right? Yeah. Deliver statements, the closing disclosure statements, right? I think you should do that, right? To your parties. Make sure that the statement is correct. Make sure that the funds have been dispersed accordingly with that closing agent. So it's very key that real estate agent works closely with the closer, the closing agent, or the attorney who's closing that transaction. They can deliver abstracts of title and documents to other attorneys. Facilitate the closing in those manners.
Let's make sure we're clear with the viewers.
Yeah.
We've went sort of at length to point out things you shouldn't do, right? Yeah. But that is absolutely based on what you just said too. We are not suggesting that as the realtors, the brokers, that the purchase agreement's done and you're done. No, I mean, you still have obligations until through closing. I mean, there's things that you're going to want to help with to make sure it goes smoothly. We're not suggesting that these rules say that you have nothing to do with closing. What we're suggesting, I think, George, is just to make sure you understand what you can do, what you can't do, and don't cross that line.
Yeah, exactly.
And again, some of the things you can't do, what about a realtor, assisting in calculating a tax proration?
No.
be careful, right?
Yeah, be careful. All right. Now, I know when realtors do their net sheets, they're going to estimate what they, okay, and that's fine. I think they have a duty to do that, right? They should. That's your due diligence. But when it comes to the actual number you're going to use on that closing disclosure, that closing statement, that's a closing agent issue.
Again, it comes back to that why take on liability? You don't have to.
Yeah, exactly. Right? Exactly.
And again, we talked about those documents, like those affidavits. How many of those documents that were on that list of no-nos that realtors can't prepare, how often do those come up in a routine closing?
Yeah, not very often. Yeah, they don't come up. The affidavits don't come up very often.
But certainly documents related to title issues, those types of things
those types of things come up all the time.
So absolutely. So again, our message, just be careful.
Yeah, our message, be careful, use your common sense. Go to your broker. Brokers, help your licensees.
Absolutely.
Hey, you want to move on?
That was a good topic. I'm glad
it's a great topic. It was a great topic.
I don't know who's more experienced.
It was a great topic.